Well, opposite to the case law, we will find the statutory law, which is the law issued by Parliament or the Congress in the case of the US. This statutory law covers both primary and secondary legislation. Let's take a look to these two types of statutory law. First, we have the primary legislation, which is that has been debated and passed by Parliament and includes both government-sponsored bills and private members' bills. When passed, bills became acts, also commonly referred to as statutes. Governments also have the power to introduce secondary legislation. This is usually done by issuing regulations called statutory instruments under provisions contained in primary legislation without the need for debate made by Parliament. So, how a bill becomes an act? Well, in the case of the UK, a statute or Act of Parliament passes through three stages. Let's take a look. In first step, we have the House of Commons. This is the most powerful of Parliament's two chambers. The chambers are usually known as houses. The House of Commons has 639 members who are elected when the whole country votes in a general election. These members are called MPs, which stands for Member of Parliament. In the second step, we have the House of Lords. This is Parliament's second chamber. Its main function is to check new bills, which are proposed by the House of Commons. This House doesn't have the power to stop a proposed statute from becoming law, but it can slow it down. This chamber has 675 members. Some are not elected by people but are appointed by the monarch on the advice of the Prime Minister. And that leads to the final step, which is the monarchy. The monarchy has to give permission before a new statute becomes law. This is because the Queen is the head of a state. The permission is called the royal assent. The monarch always accepts the advice of a government. So let's take a look to other types of legislation. In one hand, we have the delegated legislation issued by central government or local government in the other hand, such as ministerial orders in first place or local bylaws.